having a constitution, even though it does not have a single codified text. And towards the end of the session, I will speak briefly on the topic of the differences, the advantages, the disadvantages, an evaluation of codified as opposed to uncodified constitutions. And I invite you to challenge me, especially on those points, because this is a real area of debate, and it's a topic that comes up in British public law semi-occasionally, the debate around whether or not we need to codify our constitution because our political constitution and our checks and balances and our uncodified constitution are ineffective. So to begin then, part one, introducing the UK's constitution. Now, there is an incredibly common misconception when I speak to students from the continent, even when I speak to researchers and colleagues from Europe as well. There is an incredibly common misconception that the United Kingdom does not have a constitution. And this stems from the fact that the United Kingdom does not have a codified constitution. And it is accurate to say that the United Kingdom does not have a codified constitution. However, I will suggest to you today, and I hope that you will agree with me, that the United Kingdom nonetheless still has a constitution. So the United Kingdom, we don't have a single code. We don't have a single document which enshrines our constitutional laws and grants those laws a higher status within our legal system. Instead, we have a system that has evolved and which has developed over a long period of time, which arguably fulfills the same functions as a codified constitution. However, the key difference that I'll speak about in more detail later on is that the British system relies more on political checks and balances, what we would label political constitutionalism, whereas when there's a codified constitution, more power is given to the legal checks and balances, in particular the Supreme Court, who are able to very often strike down legislation being unconstitutional. And so I'd like to now explain how it is that the United Kingdom can be understood to have a constitution, despite the fact that it does not have a codified document. So in Ukraine, please forgive my ignorance. So in Ukraine, it is my understanding that there is a codified constitution, the Constitution of Ukraine, which has special legal sanctity, which sets out the framework and principal functions of the organs of government within the state, and also declares the principles by which those organs must operate. So that is what we label the narrow definition of constitutions. There's also then a wider definition and a wider understanding of constitutions and what they are. And this wider definition is more applicable to the United Kingdom. This wider definition is the whole system of government of a country, a collection of rules which establish and regulate or govern the government. And so in the UK, I'll suggest on the next slide that we fit the wider definition of constitution. We don't have a codified document, but we do have a system of rules which fulfill the same purposes that constitution ought to fulfill. So what this means ultimately is that a constitution need not simply be a document. A constitution can be far broader than a document alone. And when we think about the purpose alone of constitutions, which is what we're doing here now, it is clear that in the United Kingdom, we do have rules for how governments are formed. So how that operates in the United Kingdom is that we have a political convention whereby the king will invite the person who can command a majority of the House of Commons, which is our lower house of parliament. The king will invite whoever can command a majority of the lower chamber of our legislature to form a government. And that is usually following a general election. However, it can happen between elections with prime ministers resigning or being forced out, as we've had a lot of that in recent times in the UK. The UK also has rules which define the extent of government power. So whilst it is true that those rules are not contained in a codified constitution, they are contained in a whole range of other places. They are diffused, and by that I mean they are spread out amongst many other sources, and I'll speak about those in more detail in the second part of my presentation. The UK does have rules also for what rights that citizens have, and so whilst we don't have a constitution which sets out rights in terms of a codified document, what we do have is a long history of the common law protecting rights in the UK, and I'll speak about that in more detail shortly. But just to give you some examples of this, since 1776, the common law, so the law that the judges have developed in the UK's common law system, the common law has protected individuals in the United Kingdom from arbitrary interference by the state. How has it done this? Well, since the case of Entick and Carrington, it has been required that for government action that interferes with an individual to be lawful, there must be a legal, lawful basis for that action. If there's no such lawful basis, the common law holds that that is an interference, an unlawful interference with the rights of a citizen. So that's one example of how the common law for over 250 years has protected the rights of citizens. More recently, we have the Human Rights Act, and what the Human Rights Act achieves, I believe you were spoken to about human rights in the UK last week by my colleague, Guy Baldwin. What the Human Rights Act achieves is it incorporates the European Convention for Human Rights into domestic law, and it places duties on most public bodies to abide by human rights. And then we also have, in the UK, transparent and widely accepted rules concerning arrangements for governance. So, for example, we have very clear rules as to how the Scottish devolved government will operate and how that relationship between Scotland and the British central government will operate in practice. And so with those examples in mind, hopefully you are persuaded, and I have illustrated to you that the UK does have a system in place which achieves many of the purposes that codified constitutions also seek to achieve. And so there's a really wonderful quote here from the Cabinet Manual. So this was produced by the British government in 2011. And this is the manual which is provided to the Cabinet Office, which supports the members of the Cabinet in the UK. The Cabinet in the UK are a small group of politicians who serve as the political executive. So by that I mean they are the ones who are responsible for creating policy and leading the direction that government goes in, and they're headed by the Prime Minister, and the Prime Minister selects the Cabinet as well. But it is made incredibly clear in this Cabinet Manual that the UK does not have a codified constitution. There is no single document that describes, establishes, or regulates the structures of the state and the way in which these relate to the people. Instead, and then this is the important point for us, instead, the constitutional order has evolved over time and continues to do so. And so what this means And I'll come to speak on this point in the final part of my session today when I speak about the perceived advantages of uncodified constitutions. But what this means is that the constitution in the UK is not static. It means that it is capable of taking small, incremental, gradual steps in terms of its development. And we can contrast this with constitutional change when there's a codified constitution, where very often the changes are far more drastic. They happen much more suddenly, often after following the process set out in the constitution. So in Ireland, a jurisdiction where I have some familiarity, that is following a referendum of the people to alter the constitution. And so then if we were to define the UK's constitution, we do not have a document. Instead, the British Constitution is the collection of legal rules and non-legal rules which govern the government in Britain. So this quote now is almost 60 years old by Weir. It's a very influential text, modern constitutions. But the really important point to take away from this slide is that we're not just talking in the UK about legal rules. We're talking, in addition to legal rules, about non-legal rules. And I consider that this could be an especially foreign concept for law students and also law practitioners who are more used to the study of and practice within legal systems whereby there is a codified constitution and there is a stronger reliance upon legal rules. As I will come to explain shortly, in the UK, it is arguable that the courts do not have the power to strike down legislation that is unconstitutional. So if there was an incredibly offensive and hateful piece of legislation which went against key constitutional principles such as the rule of law, such as equality and non-discrimination, such as the individual liberty and freedom that we enjoy in the UK, the courts arguably would not have the power to strike that down after it has become law. Instead, and to explain this point, the idea would be that the political safeguards in place should prevent such legislation being created in the first place. So it's a so an ex ante rather than a post, as in after legislation protection. But not only that, in the UK, we have, according to some people, but I dispute it, a long history of democracy. But it is accurate to say that in modern times, our democratic processes have worked well to ensure that poor decisions by the government, poor pieces of legislation that may be unconstitutional, can be challenged through political processes and reversed through that way instead. So just do keep in mind that when you're thinking about the UK's constitution, the law is the skeleton, like the bones and the teeth. The political layer on top of that is the flesh and the body. And without the political or the non-legal rules, you cannot have a full understanding of the constitution in the UK. So what does the UK's constitution do? It allocates power to government and within government. So we've had some really, really high profile cases over the last 5 years in which the UK Supreme Court has been called upon to determine whether it is the executive or the legislator, so the UK Parliament, who has the power to do certain things. It has legitimacy, so it allocates power in a manner that is regarded as morally acceptable. We have accountability through both legal and also non-legal means. And I think a really important point to raise is that the Constitution in the UK applies to the entirety of the United Kingdom, even despite the fact that some powers have been devolved to the nations. So you may be familiar that Wales, Northern Ireland, and Scotland all have their own governments, who have their own legislators, who are able to create legislation and laws. But they can only do that within certain limits, and they, the local governments, are subject to legal limits which stem from the constitution, the territorial constitution. And so whilst England and Wales has criminal law, Scotland has its own criminal law, which has different standards of proof, it has different verdicts in the courts, and so forth. So we have differences in terms of criminal law, but when it comes to public law, we operate under one unitary system which applies to all of the territory of the United Kingdom. So then that brings me to part 2, where I speak about sources of the UK's constitution. So far, in the first part of my talk today, I have established that the UK's constitution is uncodified, meaning that it is not contained in one source. Instead, what we have is that there are many different sources where we can look to for the rules that govern our constitution in the United Kingdom. And I'll come on to speak to shortly. We have, in effect, a hierarchy, whereas rules from some sources are given preference over rules from other sources whenever there is a clash. So it's uncodified, but as I want to really stress and make clear, many sources of the UK Constitution are written. And therefore, while some commentators may say that the UK does not have a written constitution, I would suggest to you that it is far more accurate to say that the constitution in the United Kingdom is partly written, and that therefore it is not unwritten. It's partly written, it's uncodified, and partly written. So this is a real key point. And I'll come to explain that shortly as I work through the various different sources. So, because of that, because our sources are so spread out, because we don't give special status to our constitutional sources in any way, it can sometimes be incredibly difficult to determine what is and what is not a constitutional principle, rule, or issue. And this is because constitutional law has not assumed a legally higher or fundamental status in the UK. So this means that the source of law, so let's say 2 pieces of legislation, one of them is constitutional, one of them is not constitutional in nature. They're both legally the same. And by that, I mean they can both be amended, repealed, overturned in the exact same ways. Just because one of them is constitutional does not grant it greater protection. And so then what are these sources? I'll go through them all in more detail over my coming slides. But firstly, we have legislation. So what we would call in the UK Acts of Parliament, and then we have different kinds of legislation as well. We also have judge-made law and the common law. So this is a feature of the UK's uncodified constitution, that some of our constitutional principles derive from case law, so precedent and previous cases, rather than from legislation purely. We have the prerogative. I'll explain that when I get to it. But these basically are the powers that historically belong to our royal family and the monarch, and over time have instead come to be exercised by the government. And these are powers that are left over from when we had ultimately an absolute monarchy. We have international law, a key source in the UK. So all of those for legal sources. The fifth source are conventions and political practice. So the point to take away from this is that we have both legal and also political sources of our constitution. So it is through the means of legislation that the British Constitution has become increasingly written. So over time, more and more of our constitutional rules and procedures have come to be written down and to be enshrined in Acts of Parliament. So we've had many key reforms over the last number of years. I'll give you an example. About 5 years ago, the government created a piece of legislation that set out the rules for when we would have a general election. So they created the Fixed Term Parliament Act, which meant that we would have a general election every 5 years. Last year, so that is an example of a piece of legislation that took something that was previously ruled by the prerogative and placed it onto statute. But last year, that legislation was repealed, so it was taken away. It no longer has legal effect. And now we've gone back to the way things were beforehand, whereby the rules governing elections in the UK are governed by the prerogative power instead. So in terms of legislation then, what key things are there to take away? So number one, in other jurisdictions, there's a clear distinction between constitutional law and regular law. In the UK, that is not the case. So if we have an act of the UK Parliament, all acts of the UK Parliament are, from a legal perspective, equal, and none have additional protection because they include constitutional protections or provisions. And so what that means when I say they are equal, it means that a future Parliament can, if they so wish, amend or repeal that legislation. And it can all be amended or repealed in the same way. And so by just introducing a new piece of legislation, you could alter something that was incredibly important to our constitutional arrangements, perhaps. And that is regarded as being legitimate. According to, we have in the UK a doctrine called parliamentary supremacy, and this is regarded as being one of the most important parts of our constitution. And what parliamentary supremacy means ultimately is that it is Parliament that is the key or leading body within our constitutional arrangement, and their laws cannot be challenged by the courts. So it's only primary legislation that is protected by parliamentary sovereignty. So primary legislation in the UK is a label that can be used to describe all the legislation created by the central parliament, but also any legislation created by the devolved parliaments as well. And then secondary legislation or delegated legislation are statutes or legislation that are created by an individual under authority contained in primary legislation. So by that, an Act of Parliament may give a particular government minister the power to create certain kinds of laws subject to certain limits. And when they do so, that legislation that they create using those powers is known as secondary legislation. But we have, as I said, this idea of parliamentary supremacy. This only applies to Acts of Parliament from the Parliament in Westminster in London. it is one of the key features of the UK Constitution, one of its most defining features, and it was very famously defined in 1885 by A.V. Dicey, who wrote a very influential book called The Law of the Constitution. This definition is regarded as the orthodox or the traditional view, and it has three core elements. So the first of these is that Parliament has the right to make or unmake any law whatsoever. This means that there are no legal limits on the sorts of laws that can be created by the British legislature. In theory, it could create a law that discriminates against and targets and rounds up blue-eyed people, or people from religious or ethnic minorities, and so forth. We do not have a legal safeguard that prevents such laws from being created because we yield to this doctrine of parliamentary supremacy. So any law, no matter its moral content, no matter its substance, any law can be created by Parliament when we think about the purely legal perspective. In addition to that, not only can such a law be created, but the courts are powerless to do anything to address that, because parliamentary supremacy holds that no person or body, even the courts, are recognised by the law of England as having a right to override or set aside the legislation of Parliament. So not only can Parliament, in theory, create laws that would be considered unconstitutional, but not only that, they can ensure that those laws take legal effect because the courts do not have the power to strike down an act of Parliament. And this is obviously a key difference between the UK and Ukraine and other places where you have constitutional supreme courts who have the power to strike down legislation if it is unconstitutional. So those two elements of this definition are concerning. The third element is that a parliament cannot bind a future parliament. And so this is the only limit on the lawmaking power of Parliament. I won't go into great detail on this point, but it's incredibly interesting. It relates to the idea of entrenchment. So the idea that some people would suggest that some laws are so important that Parliament should have the ability to ensure that they cannot be overturned, amended, or repealed. That is not something that we accept in the UK public law orthodoxy. We recognise that from a purely legal perspective, all legislation can be amended or repealed. So the Human Rights Act, for example, there has been much talk of amending or repealing the Human Rights Act, despite the fact that it protects the key human rights included under the European Convention of Human Rights. And so what this means is that in theory, in the UK, we have a very high potential for abuse of the law, number one, abuse of the lawmaking process, and also, relatedly, abuse of power by the government to, without effective legal checks and balances. However, as I've stressed already today, we do have political checks and balances, which I'll speak to shortly. So beyond legislation, the common law is another key source of the Constitution in the UK. So whilst it can be suggested that the judge's role is only to interpret the law and they should not make the law, it is accepted that in the UK, judges do operate a lawmaking function, not just in common law, but also in the way that they might interpret legislation as well. And what this means is that judicial precedent, that is the body of decisions made by courts when deciding cases, is a key source of public law. And we've had many important cases here. So We have the interpretation of constitutional legislation. We have the fact that the common law has developed common law rules, what we label public law principles, which they use when they assess and evaluate government action for its lawfulness. And they've also articulated constitutional principles which influence how they interpret and apply legal rules. So it could be, for example, that they give preference to the need for Parliament to scrutinise legislation when they determine a case, for example. And so to give some examples then of some common law cases which have constitutional importance, we have the case of Burma Oil Company from 1965. In this case, Burma Oil Company sued the British government because the government destroyed oil fields during World War II to prevent them falling into the hands of the enemy. In this case, it was held that the British government had to pay compensation to Burma Oil Company. What the government did was pass retrospective, so backward-facing legislation to avoid having to pay that compensation. That's troubling from the perspective of the rule of law, the idea that law should be forward-facing and we shouldn't use the law to alter actions that have happened in the past or to alter the legal conditions in which those actions occurred in the past. Because obviously it'd be quite troubling if you did something that was perfectly legal, like wearing a white shirt, like I'm doing today, and then I upset the government, and therefore they pass a law saying that wearing a white shirt on the 16th of November was illegal, and it's 10 years in prison for doing that, okay? We also have cases that regulate the relationship between state institutions. So we have the Picken case, which did this. So regulating the relationship between different branches of the state. And then we also have cases that regulate how the state relates to the individual. So the case of Entick and Carrington, 1765, was an obligations case, a tort law case focused on negligence. And it was a claim for trespass. So this is the idea that in the case, representatives of the government raided somebody's house and seized materials and caused damage because this individual had criticised the government. The case set forth two key constitutional principles. The first, that the government cannot interfere without a lawful basis. They didn't have a lawful basis in this case. Number two, they made clear that we as individuals in the UK have what we call residual freedom. What is residual freedom? That is simply the idea that we can do anything and we have the freedom to do anything unless the law forbids it. So that is a safeguard against the arbitrary use of the law as well. We have the prerogative, which sits within the common law. This is another key source of public law in the UK. The prerogative powers are powers that once belonged to the monarch and the ones that still exist. And it's very difficult to define or agree what the prerogative is. The best definition, in my view, has its weaknesses in that it's quite circular. But any power that we recognise the government should legitimately have that does not have another source, so we can't find a source for it, but we agree that it's a legitimate power, we tend to say that therefore it must be a power that derives from the prerogative. So such powers include the treaty-making function, the ability to grant mercy or clemency to convicted criminals, the personal prerogative of the crown, of the monarch, to grant royal assent to acts of parliament so that they finally become law. And this historical hangover really reflects the fact that government used to be under the direction of the monarch. The prerogative powers can be abolished by parliament, and they're also limited by political factors also. International law is another key source. So the UK is dualist, and what that means is that when the UK signs and ratifies a treaty, it does not have immediate domestic effect. You cannot bring a claim under such a treaty in the domestic courts. Instead, Parliament must incorporate that into domestic law through legislation, and that is a dualist nature. Other states, such as the Netherlands, are monist, whereby when they sign and ratify a treaty, it has immediate legal effect. So dualist, that means that we do have some that we brought into domestic law. They have an influence. There's also some that are regarded as having an influence, even though we haven't brought them into domestic law. And the courts, the way they do this is they have a rule of interpretation, whereby when they are interpreting the law, unless the law explicitly forbids them from doing so, they will seek to do so in line with broader constitutional and including international law principles. And then finally, we have the political conventions. So these are the parts of the convention which are not strict rules of law. They are the unwritten rules of the game. They are the accepted practices which all parties implicitly agree to. And traditionally, these have been unwritten, and obviously that has its own risk and implications, but we are seeing some of them being written down now. So the ministerial code has been written down, and that sets out the standards of behaviour which are expected of civil servants in the UK. But even though it's been written down, it's not the law. It's still formally binding only in the written sense. In the political sense, it's only formally binding. And you could not enforce these through the court. So what we rely on is people being willing to be bound by convention. So for example, the fact that a government minister will resign if they are found to have misled Parliament is a convention. Historically, government ministers have abided by that, but Boris Johnson, the Prime Minister, refused to resign, even though he had misled Parliament. And in the end, we had political processes within his own party, so party political rather than constitutional political, which acted to remove Boris Johnson as Prime Minister, because whilst he as an individual was unwilling to follow the convention, his party believed that he ought to follow the convention, and therefore they enforced it upon him. And so then this brings me to my final part before I wrap up, where I'd just like to compare and contrast codified and uncodified constitutions in a very general sense. And I say this very generally because obviously codified constitutions are not the same everywhere. There are differences between them, but I'd just like to draw out some common themes. So the UK differs from many other countries in the world because we do not have a codified constitution. That means that our fundamental laws are not all in one document, as I stressed in part one, and it means that everywhere else in the world, generally speaking, the courts have the ability to find law to be unconstitutional and therefore mean that it has no legal effect. We don't have that in the UK. Why don't we have that? Well, we did have a revolution some 300 years ago. We went back on the revolution in terms of we got rid of the monarchy and then we brought the monarchy back. Since then, we have not had a constitutional moment. So we've not had independence, like because we were one of the countries that many states in the world were gaining independence from. We've not had a revolution, although arguably we did come close in the early 1800s in terms of class and socioeconomic issues rising to the fore. And because of that, we've not had a reason that has forced us to adopt a constitution. And we've been quite happy to just amble along with our current constitutional arrangements, irrespective of the weaknesses, because we just say to ourselves, well, it works. And because it works, we're not going to tinker with it. It's easier to just carry on as we are. Arguably, and I alluded to this earlier as well, uncodified constitutions are more flexible in the sense that whilst both uncodified and codified can be changed, uncodified ones like the UK can progress incrementally, more slowly, whereas change to codified constitutions tends to require quite a long and difficult process, normally a referendum, so you have to build a lot of political support around an issue. So it's normally for much more impactful changes rather than smaller changes. So this can be quite a good thing, this flexibility, in the sense that it can allow the constitution to advance as society advances morally and progressively. But there are also risks associated with this, because what happens if society goes backwards with respect to progressive issues? So issues such as gender equality, issues such as equality for people of different sexual orientations, all of these sorts of issues. This flexibility also means there's a risk that some of the advances we've had in the UK could be rolled back. But the counterpoint is, so like obviously lots of calls for reform of gun laws in the United States, which are constitutionally protected. It's very difficult to change that. Whereas in the UK, we had a mass shooting in Dunblane, unfortunately, in a primary school about 25 years ago. And pretty much immediately, we were able to reform our gun laws. And since then, we've never had a mass shooting like that. So there's advantages, there's also disadvantages. A key argument is that not having an uncodified constitution, not having a codified constitution, sorry, is inherently more democratic. And the reason for this is codified constitutions tend to set the limits within which political parties can operate. So political parties cannot promise certain things that are unconstitutional, because it would be impossible for them to bring those changes in practice. In the UK, political parties can promise things even if they go against the current constitutional arrangements. So, for example, this doesn't have to be infringements of individuals. This could be changing the makeup of the House of Lords, so the composition of the House of Lords. We've had lots of reform there. Changing our highest court. So the UK Supreme Court has only existed since 2009, for example. All of those things were promised by political parties, and they were able to make those promises, and they were able to get the democratic support to do so, because they didn't have a constitution acting as a narrow constraint on what they could or could not achieve. But as well as that, democracy arguably acts as a safeguard against abuse of power in the UK, because we saw this with Liz Truss when she was Prime Minister for a couple of weeks. She made some changes to the direction of government policy. Those changes were very unpopular, and it led to her downfall, and she was no longer Prime Minister, because it was very clear that the general public were against those policies. And then finally, but really importantly in the UK, we have political constitutionalism. So we have less legal safeguards, and therefore we rely more on these political safeguards. So we rely on the voting public. We rely on general elections every 5 years. We rely on local elections that are more frequent to apply pressure as well. We rely on conventions. And today, largely, these political conventions have been effective in the UK, and that is why many people are resistant to changing our system to more legal protections. However, how long will that be the case? We don't know. There's a risk that we could have extremist political parties whereby these political safeguards are ignored. We saw that with Boris Johnson, ignoring some political safeguards. And when that's the case, there is a risk that we may get to a point in the future where we need legal safeguards, but it's too late, and we don't now have the mechanisms and the powers to bring them in, because the government in power is against them. And so I've recommended some reading. I did send the slides so they can be distributed. There's a really great book that introduces the UK's constitution by Oxford University Press. there's a summary produced by the UK government in 2015, and then a really good textbook, arguably the best one in the UK, is Public Law by my colleague Robert Thomas, and then also Professor Mark Elliott, who is a professor at Cambridge University. So that brings me to the end of my presentation today. Thank you so much for listening and bearing with me. I hope you found it interesting, and of course, I'm very happy to take any questions that you may have.
Good afternoon. My name is Nicholas. I'm an international law student of the Tax University of Irpin, and I have such a question about this topic. Have there been any recent drafts of a single written constitution that you think could be adapted? What is the most challenging issue that would be difficult to resolve in such a document?
Yeah, so I think that's a really excellent question. So there's different approaches that we could take to codification. So one approach, which is arguably the least controversial, would be to simply bring together all of the sources that I spoke about today into one place, into one act of parliament, perhaps, and do it through that process. The reason why that would be the least controversial approach is because it would ensure that we maintain parliamentary supremacy. It would be an act of parliament that could be changed by parliament and so forth, but it would codify everything into one place, and that would make it far easier to know what the constitutional limits and safeguards are. That's one approach. Other approaches, of course, will be far more progressive, perhaps, and rather than just codifying what we have now, they could, in fact, try to bring about a new constitution, one which maybe better reflects certain features and different issues. So maybe one discussion that we've had is having protection in the UK against destitution, so a constitutional protection against extreme poverty, so that the government has a duty to protect against that by providing support and so forth. The issue with the second approach, I'll start with why it's not happened there, is that, as I'm sure you'll be aware, it can be incredibly controversial as to what should or should not be included in the Constitution, as to what should or should not be deserving of constitutional protection. So if I was to generalize, the Conservative Party, so one political party, our current government, would be more inclined to only really protect individual liberty, and they would very much focus on the state not interfering with people. However, arguably, other political parties, perhaps the Labour Party, might also want to think about positive obligations for the state in certain circumstances. And what this point really comes down to is that there's a complete lack of agreement about what our constitution should look like. And therefore, there's a barrier to creating a new one that changes our existing structures, if that makes sense. In terms of why don't we just codify what we already have, that there's similar issues. And I think there's concerns that through doing that, we could have unintended consequences through which perhaps we change the balance. So rather than just writing it down in one place, the pure act of writing it in one place disrupts the constitutional order. And that brings me on then to a key point, is that there's a real fear of disruption, a fear that what we have now works, and therefore we should stick with it rather than going through the period of disruption. And then my very final point is a legal one, in that the doctrine of parliamentary supremacy requires that Parliament can pass any law it so wishes. If we were to codify a constitution, that would directly challenge parliamentary supremacy. There are workarounds around it, but that would potentially mean that Parliament is unable to make any law that it wants to, and that is a pillar upon which our constitution rests. And so to take that away, the implications of that will be incredibly vast, and I think there's lots of fear about what that could look like in practice.
Thank you.
You're welcome.
May I, please?
Yeah, of course.
Okay, we are from State Tax University, and my question is, how often are the laws that form the basis of the British Constitution amended or revised, and how exactly this process takes place, and who conducts the examination of such bills?
So the question then, and correct me if I misheard you, but you're asking how the sources of the British Constitution, how are they amended legally? Is that correct? And who oversees that? Okay. So I just progressed on the assumption that I interpreted the question correctly. So one of the most powerful actors in the British Constitution with respect to this is the courts. So when it comes to determining the limits of constitutional powers, it's the courts that have set limits, and they have tended to do so by relying on key principles such as the rule of law, such as the separation of powers, and so forth. The courts are quite reluctant to have a very proactive and progressive approach to the Constitution, by which I mean they don't use those powers to advance the Constitution in any controversial way. Instead, what they do, they use those powers to prevent the government advancing the Constitution in a controversial way. However, because the government in the UK, our cabinet, our government, our prime minister and so forth, that they have a strong voice in Parliament, our legislature, and we have a strong fusion of powers between our executive and our legislature. The government can pass legislation via Parliament, which amends the constitutional order. So I'll give you an example. The Constitutional Reform Act in 2005, it had three key effects. So number one, it changed the role of the Lord Chancellor, who historically was in charge of the judiciary. It changed that, massive constitutional implications. Number two, it changed the appointment process for judges. So obviously, how you appoint judges can potentially really impact on the constitutional settlement. And it also created the UK Supreme Court. So it established the highest court in the land. So massive implications for judges on the whole, okay? That was done through an ordinary act of Parliament. So then we're really reflecting on what are the ordinary processes in place that oversee acts of Parliament. So ordinarily, the government proposed legislation to Parliament. The House of Commons, so the lower chamber, the elected chamber, they debate it. And if they're happy with it, it goes through to the House of Lords, and then they do the same. And then there's a back and forth process. And then if both houses approve it, it goes to the King, who gives it royal assent, which is a stamp. They just always give it by convention, and then it becomes law. So the process is the ordinary lawmaking process. The safeguards we have are the House of Commons, so political safeguards because they're elected, they want to get re-elected. In theory, they shouldn't create legislation that will not get them elected at the next election. We also have parliamentary scrutiny. So we have committees in Parliament who can question ministers, they can scrutinise legislation. We can have open questions and debate in Parliament as well. And ultimately, we have to keep in mind that whilst we do have a system whereby members of Parliament are often expected to vote in line with their party, they are able to ignore that and face the consequences. And therefore, we have individual people voting in our legislature whether or not to create these constitutional changes. For some of the most major changes, perhaps now we can agree that there is a convention that we should have a referendum. And so Brexit, for example, the process by which we left the European Union, that stems from a referendum. But that is not required. And the referendum also is not binding. It only has political bindingness.
Can I ask?
Of course, yeah, please.
Yeah. My name is Vsevolod, and I am a student of State Tax University. And what about my question? The field of your research is human rights in the United Kingdom, including the human right to adequate clothing. Why did you focus on this particular human right, and how relevant is this issue today?
Okay, so thank you for your question. My research really, if I was to describe my research in a sentence, is poverty and the law. I've always been interested in the interaction between poverty and law, including public law and human rights are the area through which I approach that issue. So my PhD, I looked at the relationship between poverty and human rights law. And in doing so, one of the rights that exist in the International Covenant on Economic, Social and Cultural Rights is the right to clothing. And when I was writing my PhD, it became apparent that there was very little research on the right to clothing. And so whilst my main area of research is poverty in the law and the relationship between poverty and public law and human rights, I kind of now have a side track where I'm looking at the right to clothing and seeking to bring some clarity to that right. So why do I think that's important to do so? So there are three key reasons. So the first one is an appeal to authority. So in my view, in 1966, when the countries of the world signed and ratified the International Covenant on Economic, Social and Cultural Rights, since then, since every state that has signed up to it, when they've ratified it, all those states have agreed and they have brought into the world a right to clothing through positive law. So take aside natural understandings of natural law rights, we have a treaty that requires that there is a right to clothing. So I believe that we need to bring clarity to this right so that states are able to fulfill their treaty obligations. The second key reason that I believe the right to clothing is important is that there are certain harms that only exist due to lack of adequate clothing. So I could go through lots of different examples, but I'll give one. There is a disease that exists largely in certain parts of Africa called podicosis, and that disease results in inflammation of the feet. And this disease is caused by the fact that people walk barefoot over certain soil which contains certain bacteria. And if people wear shoes, it's impossible for them to contract this disease, okay? So this is an example whereby a lack of shoes is resulting in illness for people. And there are many other situations in which clothing can be harmful. And I believe, and I argue, I have an article that's been accepted, that's forthcoming, that there are certain harms that only come from clothing, and therefore it is the right to clothing that should address them, because other rights are incapable of fully capturing the essence of and addressing those harms. The third reason is an instrumental argument. The enjoyment and realization of so many other human rights that I believe if we use the theory of indispensability, which a number of scholars have written upon, that clothing is indispensable for the enjoyment of human rights, and therefore we should be recognizing the pre-existing right to adequate clothing to ensure that people have adequate clothing and therefore are able to enjoy and realize their other rights. So to give you examples, the right to health is obviously a really important example. The right to freedom of expression. If I want to wear certain clothing to identify with a particular group, be that a religious group, a minority group, or a subculture, I should have the freedom to do so. And if there's a good reason that I shouldn't be able to do that, there should be a lawful process which limits my ability to do so. And I think that can be achieved through clothing rather than other related rights. So hopefully that explains how I've come to this right, explains why I think it's important. In the UK context, I've been doing lots of work with charities that provide clothing to people that can't afford it. And what we're seeing is that increasingly people are unable to buy new clothes just due to the fact that our level of social protection in the UK in terms of the people at the lower end of our income spectrum, people on their social security benefits, they're not receiving enough to pay for housing, to pay for utilities, to pay for food. Those are your three priorities, and then to pay for clothing as well, unfortunately.
Thank you for your answer.
You're welcome. So I think somebody might be speaking here, but they are on mute.
I didn't saw. Oh, hello. We are the teachers and students from Tax University. We were hearing from the audience, and we want to thank you very much for your excellent lectures. It was very relevant for us and for our students. And of course, we look forward to work with you, with Manchester University, and we hope it will be soon in the future also. So I want to say also special thanks from our Department of Theoretical and Legal Disciplines of our university, State Tax University, and from all our students. They are sitting here. Say hello. So, and a special thank you for Valeria Antoshkina, who helped us in the organization of these open lectures with the teachers of Manchester University. So thank you very much, and we will hope to see you soon.
You're most welcome. Okay, goodbye, everybody. Have a wonderful day. It's been my pleasure.
Thank you. Bye.
Have a wonderful day too.
Bye.
Thank you. Bye-bye.
Bye.